Thank you, my Lord. My Lord, before the short adjournment, I was just looking at Gator, and there is one final paragraph that I should like to refer the Court to, if I may, which is at paragraph 79 at MS page 724, page 605 of the Gator report, which is tab 10 in the authorities bundle.
I mean, the difficulty with this is that it's authority, depending on which judgment you look at, for almost any proposition, isn't it?
Well, it is an interesting judgment, certainly, in that respect.
Lord Justice Buxton doesn't agree with this passage, does he, in particular?
No, but the passage that I'm taking you to does illuminate, I would respectfully submit, the point that I was making before the short adjournment, that in the domestic context, you've got 28 days to challenge an award, and he there speaks about the loss of the right to challenge and reaches a conclusion in that paragraph that why should somebody who fails timiously to challenge an award take himself outside of the jurisdiction to order security that we find in section 70. Which was, I only bring it to the Court's attention to underpin my submission that I was making before the short adjournment this morning. In addition, we have provided the Court with a copy of the Jaffrey case, which Lord Justice Ricks referred to in paragraph 77 on MS page 723. I think it's fair to say that the case says no more than Lord Justice Ricks said it did, in that paragraph, that save an exceptional case where there may be an appeal out of time, a judgment, debtor complaining of fraud will be required to commence a new action. And for my Lord's note, I won't take you to it in the interest of time, if I may, but the reference should be to paragraph 20 of the judgment in the Jaffrey case.
Sorry, and how does this relate to arbitration?
Well, it doesn't.
I see.
It's not a case about arbitration. I think the point Lord Justice Ricks was making, that if one's then into one's common law remedies outside the Arbitration Act, then there should be a separate action to impeach the award. But I think the whole thrust of what he was saying was you bring a timious challenge under Section 69, and no doubt if you don't discover the facts to support a Section 69 challenge, then it may be that somebody may be given permission to bring a Section 69 challenge out of time. But once you are within Section 68 and 69, then you are subject to the regime of the Act which provides for security. My Lord, I think it goes no further than that. My Lord, may I then move on to follow my learned friend's course and deal with the question of, in fact, what the Court of Appeal actually did and the nature of the order. The problem facing the Court of Appeal in this case was that there was at the time no extant Section 1033 challenge. My learned friend says, and that's not right, we'd made the application back in December of 2008, but that had been compromised on the basis that there was an adjournment under Section 1035. The 1033 challenge could easily have proceeded.
Wait a minute, I mean, you say it's been compromised. Doesn't seem to make a great deal of sense of what Mr. Justice Field or the Court of Appeal were doing when they were investigating whether there was a prima facie defence, if there wasn't such an issue in the arena. No,
my Lord, when I say compromise, perhaps it was not pursued at that time.
No, because there was an adjournment.
There was an adjournment.
As soon as you decide that there shouldn't be an adjournment, the defence or the riposte springs into life again, doesn't it?
My lord, that is so. It wasn't, but at the time the Court of Appeal was deciding this, the position of NMPC was this. It was saying, we will bring a 103.3 challenge, even if we will bring it at the end of the adjournment. And so they were saying that we still have this right. One has to look at the context of it, because what we were seeking was actually for the adjournment to be lifted. And the argument against us was, well, even if the adjournment is lifted, there will still be, at the end of all that, a 103.3 challenge. Therefore, do not lift the adjournment. And that was the Gordian knot.
Well, yes, you say there will be, there is. Okay, there will be. But the argument failed, so there is an adjournment, so the challenges are there.
But my lord, what they're saying is we were not bringing that challenge. What NMP was saying was continue the adjournment indefinitely, because it gets you nowhere to stop the adjournment, which is what we wanted, because it still won't result in an enforceable award, because then we would have a Section 103.3 challenge. So what the Court of Appeal was doing was trying to bring that challenge forward and get that decided, so that it could solve the whole of the matter that was before it. Because the
need to bring it forward. It's there, and that's why they were discussing whether there was a bona fide defence as soon as you lift the adjournment. I mean, the challenge is there. You only, and it's going to be fought out.
Well, my lord, it was
to bring it forward.
Well, the argument was that the adjournment should continue.
Yes, of course.
Yes.
But the argument failed, and so one asks, what's the position when there's no longer an adjournment? The answer is there's an objection on the grounds of public policy. My lord, yes. And non-fraud objections as well. Yes. Well, the non-fraud, chronologically, they come in later by agreement. They come in later by agreement, yes, my lord. So we're talking about the fraud ones at that stage. So at that point, the Court of Appeal was extending the adjournment and ordering further security. Well, why was it extending the adjournment? It wasn't. It was lifting the adjournment. It didn't lift the adjournment, no, my lord. It extended the adjournment. Well, I know, but
that's what they said they were doing. They weren't. I mean, what were they adjourning? When you adjourn proceedings, you make an order, the effect of which is that they're not going to be heard, not for the time being anyway. Whereas they were actually directing that the issue be tried. It's not an adjournment simply to contemplate the fact that it will take some time to fix a date for trial and argue it. But, my lord, it wasn't in those terms, because the challenges in Nigeria have never been withdrawn. So the challenges were always there. There was always jurisdiction under 103.5 to continue the 103.5 adjournment. But they didn't do it. Well, my lord, they did, at least in the second limb of the order. 2A?
But no, 2B.
In 2B, rather.
But I think the point being put to you is it doesn't make sense, basically.
I mean, that's what it says. A further enforcement of the award should be adjourned. But, I mean, can you tell us what was the further enforcement of the award that was being adjourned?
Well, what had happened? Well, in fact, what the Court of Appeal decided was the award should be enforced, but for this challenge under 103.3.
Well, that's what the convention provides. But what do you say was the further enforcement of the award, which was adjourned by paragraph 2B?
Because the Court of Appeal...
Now, I'm asking you, what steps were being adjourned by that phrase, further enforcement of the award?
Well, my lord, I would argue that the award was immediately enforceable as a result of the Court of Appeal's decision, but there were still extant challenges in Nigeria. They permitted the award to be that enforcement that they had decided could have been immediate, but there was a threatened 1033 challenge, and therefore they continued the adjournment in order that the 1033 challenge could also be made.
That's prejudging it. You can't treat something as enforceable before you've heard whether there's a defence or answer to it, enforcement.
They found but for the threatened 1033 challenge, the award would be enforceable. May I take you to the judgment itself?
That must be the case in every case where there's a challenge. So, I mean, does your proposition amount to this, that there is in every case power to, as soon as there's an attempt to enforce an award and an objection, in every case there is power to grant security, because it's going to take a little time, even if it only takes over the lunch adjournment, to resolve the problems.
My Lord, at my case at its highest, I do say that there is power to order a challenger to an award to give security.
Because you're adjourning?
No, not because I'm adjourning.
Well, that's what I wanted to test you on. I mean, if you're to defend the order, paragraph 2b, it seems to me that it does go to that length, that in any case where there's an issue, I mean, if there's not an issue, then the question falls away, because, of course, you order immediate enforcement. But in any case where there's a defence put up, or an answer put up, since it's going to take, at any rate, a few minutes to decide whether the answer is good, or it may take a hearing and a judgment, there is an adjournment in the sense of section 1035. Do you say that?
I say that where there is a challenge at the seat, there is jurisdiction to maintain the adjournment rather than enforce immediately.
I see.
Which is the jurisdiction under 1035.
Wherever there's a challenge at the seat, at any rate.
Yes. I accept...
Even though you haven't decided to adjourn pending that challenge, you've decided to make up your own mind and leave the challenge in the foreign jurisdiction to just evaporate, disappear into the mists of time in this case. So even though you're not adjourning pending the foreign challenge, you say there's jurisdiction under 2F and under 1035?
My Lord, well, of course, one has both the authority of this case and Soli Boni itself, that it is a matter of discretion in each case as to whether A, there should be an adjournment pending the challenge at the seat, and B, whether there should be security. But what I do say here is, in this case, the Court of Appeal, having looked at the matter carefully, and it's fully reasoned in its judgment, decided that it was an appropriate case for the increase of security, and the challenges were not withdrawn in Nigeria, and there was certainly no suggestion to the Court of Appeal that the challenges would be withdrawn in Nigeria, and so Section 1035 jurisdiction would exist unless and until the Nigerian challenges were withdrawn. And then the Court of Appeal very clearly reasoned why it felt that an increase of the security already ordered was appropriate. And perhaps I needn't take you to it in detail, but in the supplementary judgment, paragraphs 20 to 24, which you'll find in the core bundle behind tab B at MS 172, it gave the reasons to mitigate further prejudice to IPCO by a further round of attempts to avoid payment of the award. And
the attempts to delay payment of the award, is that a reference to the fact that they claim to have a defence, and indeed that it's been held to be a bona fide defence?
Well, my Lord, the Court of Appeal is looking at the whole history. It looked at the whole history of the proceeding, as it did say in, if I perhaps take it to the supplementary judgment.
What is this? You seem to be submitting that there is something wrong with raising a defence to the enforcement of an award, which is specifically allowed for by statute, and which is supported by a good prima facie case.
No, my lord, I wouldn't dream of submitting that. Can I take you to what the Court of Appeal said, which you will find at MS 172,
Yes.
behind tab 8. So the Court of Appeal particularly at paragraph 22, looked at the history of the proceedings. Their inordinate delay persuades us of the need to provide an incentive, indeed something a goad to progress.
Well, what's the basis for that?
Well, my lord, it's their view of the overall.
There are findings that they make in their main judgment that no one is to blame for what's happened, and so there's been most regrettable delay, but why is that a basis for requiring an incentive? What is there to prevent, to indicate that the London proceedings won't proceed rather more expeditiously than the Nigerian?
As indeed they have.
As indeed they have, and they are bound to,
Yes, quite.
given the history of the Nigerian proceedings.
I mean, does one normally look at defendants and say, we're worried that you might delay or try to delay? We haven't got any grounds for thinking you have done so far, but as a result of that, you're going to have to bring the whole of the sum into court. I think that would be very unusual.
My lord, yes, the Court of Appeal, in the exercise of discretion, was, in my respectful submission, I mean, the words speak for themselves. They are entitled to look at the entire history of the matter and form a broad view where the justice of the situation lay. And they saw the delay. They saw that the delay had eroded the value of the security. And so they decided the security should be increased. As I say, as a matter of discretion, I don't think I can put it any higher than that. That's, of course, if we're dealing solely with the question of whether the order could have been made only under 1035. We do submit that there was nevertheless a power, and we rely upon the CPR, to make such an order in relation to a challenge under 1033. We accept it's not a power under the express provisions of the 1996 Act, but we do say that the powers in the CPR are expressly recognized by the New York Convention, and there is no inconsistency with the New York Convention. My learned friend's already taken the court to CPR Rule 3.13. I won't take to you again. And also to Article 3 of the New York Convention. But I would like to emphasize something about Article 3. So I apologize for taking you back to it, but it is very much at the core of this case. And the Convention is in Authorities Volume 2. And Article 3 is at MS page 868 behind tab 22. So each contracting state shall recognize the arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon conditions laid down in the following articles. There shall not be imposed substantially more onerous conditions or higher fees or charges on the recognition or enforcement of arbitral awards to which this convention applies than are imposed on the recognition or enforcement of domestic arbitral awards. So the scheme is focused very much upon the obligation that each state shall recognize an arbitral award as binding, subject to the particular substantive defenses and subject to local procedural rules, as long as those procedural rules do not fetter enforcement, so silent on the question of whether they fetter challenge. My little friend took you in part to what Professor van den Berg commented on it. Can I take you back to that passage, but some further passages, if I may, which is in the same bundle. It's in fact the next tab at page 893, where Professor van den Berg begins this section. This history of Article 3 of the Convention shows that the rules of procedure for the enforcement of a Convention award are left to the law of the country where the enforcement is sought. Generally speaking, there are three possibilities for regulating the procedure for enforcement of a Convention award. One, specific provisions. Two, enforcement as for a foreign award in general. And three, enforcement as a domestic award. May I then ask you to pass on to page 895. The only directive which Article 3 gives for the procedure for enforcement of a Convention award is stated in the second sentence, which, as noted, was inserted at the instigation of the ECOSOC Secretary-General, the United Kingdom delegate. As far as it could be researched, the contracting states have not imposed more onerous conditions or higher fees or charges for the recognition or enforcement of Convention awards than are imposed on the recognition or enforcement of arbitral awards under their own law. And then, going on to a passage that my learned friend took you to this morning, but if I could just read on from where he read on. My learned friend finished, I think, reading at the sentence that ended embodied by Articles 4 to 6. So may I ask the court to read on? Thus, the petitioner only need to submit an original or copy of the arbitration agreement and arbitration award, and possibly a translation, Article 4. The enforcement may be refused only if the respondent can prove one of the grounds listed exhaustively in Article 5.1 or on public policy grounds by virtue of Article 5.2. This implies also that the respondent must be offered an opportunity to be heard during the proceedings concerning the request for enforcement or proceedings in opposition to granting of leave, as the case may be, according to the procedural law of the forum. In addition, and this may even be an innovation for certain procedural laws, the decision on the enforcement may be adjourned if an action for setting aside the award is pending in the country where the award was made. Article 6. This is the point I referred the court to this morning, which is why I would respectfully submit it was necessary expressly to refer to that power in Article 6. But passing down the page, again, a point made by my Lord Toulson this morning, I think, is probably addressed here. In this connection, it may be observed that the use of the wording shall not impose substantially more onerous conditions in the second sentence of Article 3 is somewhat confusing. The word conditions, as used in the second sentence, must be deemed to relate to the conditions of the procedure. In other words, the rules of procedure. It does not refer to the conditions under which the enforcement of the award is to take place, in which case the word is employed in the first sentence. Article 3 can also be considered as the basis for the application of the law of procedure of the forum to those aspects incidental to the enforcement which are not regulated by the Convention, and the learned professor emphasizes those words. Attachment in connection with enforcement of the award is one such example. Others are discovery of evidence, set off of a claim against the award which is sought to be enforced, and bankruptcy of the party. The question of estoppel of the right to invoke a provision of the Convention could be similarly considered as pertaining to the law of the forum, although it is arguable that this question is implicitly regulated by the Convention itself. Furthermore, the procedural law of the forum may impose time limits within which the enforcement of a Convention award may be requested. We say that the provision of security falls within that broad description of the matters not regulated by the Convention and regulated by the procedural law. I said there was an English case which considered this, and that is the case of Diag Human against Czech Republic, 2004, a decision of Mr. Justice Burton. It's found in Authorities Volume 1 at MS page 617. That's tab 7. In that case, it was another case where an award debtor sought an order for security for its costs against the award creditor. Mr. Justice Burton found there was jurisdiction to make the order, but declined to do so, and in his judgment, he considered the structure of the New York Convention. He cited Professor Vandenberg at paragraph 14 of his judgment, MS page number 622. But if I may then go on to read the next paragraph, after the passage which we've looked at from Professor Vandenberg's book, he said this: "It is quite clear that the local court is free to impose its own procedural conditions, such as orders for disclosure, indeed time limits for evidence, and in respect of compliance with those conditions, to make final or unless orders, and in the event of failure to comply with such final or unless orders, to impose sanctions including dismissal. It is plain to me that this must also include security for costs, if otherwise appropriate and so long as non-discriminatory. And the fact that there is an express remedy given by Article 6, whereby a defendant may be liable for security in respect of the award and or for costs, does not, in my judgment, take away the effect of the second sentence of Article 3, which permits the imposition of conditions and hence inevitably of sanctions for non-compliance with them, including a dismissal, which would not be offensive to Article 5. Then just as the next paragraph, the first sentence, non-discriminatory conditions can be imposed as a result of the second sentence of Article 3, and the sanctions for non-compliance must include dismissal." Now, this, of course, is in relation to an application by an award debtor that the award creditor provides security. But we say that his analysis is nevertheless correct. The only fetter placed by the New York Convention on the procedural as opposed to the substantive rules of the place of enforcement is that they should not be more onerous than those attaching to the enforcement of domestic awards, not attaching to the challenge. There is nothing in the New York Convention to prevent a state imposing any procedural conditions on the enforcement or recognition of award as long as they do not discriminate between domestic and international award creditors.
But Article 3 is talking about placing an onus on the creditor. What's it got to do with placing an onus on the debtor?
Well, that, my lord, is the entire point, that the Convention is silent on any prohibition on the imposition of conditions upon the right to challenge under Article 5.
Okay, well then, sorry. Well, if then you go back to the passage of Vandenberg that you were citing, that Article 3 can be considered as the basis of the application of the law of procedure of the forum to those aspects incidental to enforcement, and if it be right, for the sake of argument, that the imposition of security on the debtor as a term of being able to advance his defence is a procedural matter governed by the law of the forum, that then raises the question, well, where in the law of the forum is that power to be vested? Not in the Arbitration Act, I don't think you suggest.
No, my lord.
So you come back to CPR 3?
I do, yes, my lord.
Yeah, that has to be your reason, your only route.
That is my reasoning, yes.
You must, on your case, this decision of Mr. Justice Burton must be wrong, mustn't it?
No, my lord.
Well, it must be, because you can't have a situation where you could imposed an obligation for security costs on both parties, he must be accepting Lord Justice Buxton's view of enforcement, namely that the effective claimant is the party seeking to enforce, rather than Lord Justice Ricks's view, because otherwise he couldn't have imposed security on the party seeking to enforce.
He wasn't imposing security.
Yes, it was. He was saying, surely he was saying, you must put up security for costs of the enforcement procedure, since you're applying for enforcement.
Yes, my lord. He did find that yes, there was jurisdiction.
Yes.
He went
jurisdiction to impose requirements of security for costs on both parties, can there?
My lord, I would say that there can be, depending on which hat that they're wearing. In the case of a challenge,
You're enforcing and you're objecting, both of you as bad as each other. You can both put up security. Is there any other context where that happens?
I'd have to think about that question, my lord.
Anyway, it may not matter because, I mean, there is obviously a difference between Lord Justice Ricks and Lord Justice Buxton, and as I see it, Mr. Justice Burton must implicitly have been following Lord Justice Buxton's view, but
Yes.
where it takes you in terms of security for the sum in issue is, of course...
Well, yes, because they're always... this is all about security for costs. And, of course, security for the sum in issue hardly could logically arise where we're talking about the award creditor paying. So it could only be security for costs, which is why I took some exception to my learned friend's submission about the raft of cases that he spoke about this morning, because they're all award creditor cases. We say...
Just ask you about Article 3 before you
yes, my lord.
leave this subject. I mean, you submitted that Article 3 is actually concerned with conditions upon enforcement rather than conditions on challenging enforcement.
The restriction in Article 3 is on the conditions.
I simply wonder whether that's right. If you look at Article 3, it first says that the states must recognise arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied on. Now, those rules of procedure will contain rules governing the conduct in the course of enforcement proceedings of both the creditor and the debtor. Now, you're not suggesting, presumably, that the rules of procedure referred to here are only the ones that govern the behaviour of the award creditor.
No, my lord.
Why should the position be any different when it comes to the question of the conditions? Surely the article is not referring to conditions on enforcement, it's referring to conditions which are relevant to enforcement proceedings, those conditions being set out in the following articles, some of them relating to the position of the creditor and some relating to the position of the debtor.
My lord, because it's the second sentence. Well, first of all, the following conditions don't relate to the position of the creditor in terms of putting any restrictions on the right to challenge. It is.
I see the force of your point that the second sentence is concerned with making it more difficult to enforce rather than making it more difficult to challenge. But the first sentence, I mean, it's been observed by many people, it is clearly right, that conditions is being used in two rather different senses.
Yes, my lord.
The object of the first sentence, surely, is to ensure that the acceptance of the right of enforcing courts to apply their own rules of procedure is not to derogate from the conditions referred to in the first sentence, which are the conditions in the rest of the convention. And those conditions do not just relate to the position of the creditor. It would be very extraordinary and one-handed if they did.
No, there are clearly in the convention laid down the substantive tests or conditions which the award debtor must fulfill if he is to challenge
but also procedural conditions one of which is Article 6.
Yes, but nothing, but we're not suggesting anything that derogates from those substantive conditions at all. And, for example,
Derogation is probably the wrong word, but what is surely being said is that that so far as Articles 4, 5 and 6 apply, they are to apply to the exclusion of any corresponding provisions which may be more or less onerous than the domestic procedure of the enforcing court.
I respectfully agree, my lord, and that's, of course, was the Italian Supreme Court case that my learned friend raised, where in that case there was, if I understand it correctly, a presumption that if there was a lis alibi pendens in an Italian court, then one wouldn't enforce the award, which would be clearly a derogation from...
Yeah, but that is slightly different because it's not a matter dealt with elsewhere in the Convention, except in relation to proceedings in the Curial Court.
Well, that was found to be offensive,
Yes.
because it was a fetter on the Convention, whereas all of the commentators seem to follow Professor Vandenberg and hold, for example, that it's appropriate to apply time limits, which I think one of the commentators says that range in various jurisdictions from 3 months to 30 years.
That is a matter not dealt with in any part of the Convention.
It is not. And so we come back to the point where is the reference in in Article 6 of the Convention enough then to displace, as it were, the procedural rules of the enforcing court, where it would normally apply security in the form of depositing part of the award? And I would say no, my lord, because I would say that Article 6 does not occupy the same territory. We come back to that. It occupies different territory where there is not a challenge at all before the enforcing court, but a challenge elsewhere. And yet the enforcing court is empowered to wait for that challenge to occur. And as I say, as Professor Vandenberg observed, that may have been an innovation under certain procedures. So it does come down to the question of whether or not the reference to security in Article 6 precludes any other security being ordered as part of the procedural rules that are preserved by Article 3, and I say not. As I say, it's of a different quality entirely.
Can I put a slightly different angle on the questioning? I think we were shown material which suggested that the second reference to conditions should be read as a reference to rules of procedure.
Yeah.
So that, again, picking up Lord Sumption's questioning, if that were right, then the second sentence would apply both ways again, wouldn't it? Shall not be imposed substantially more onerous rules of procedure.
Well,
and like the first sentence, that would be capable of, on an enforcement, on a that would be capable of applying to either party.
I'm not sure that's right, my lord. I think that Professor Vandenberg says that the second reference is to the substantive.
No, the first reference is the substantive one, can only be, and the difference must be the second reference is not. The second, he reads, I'm just reading page 896.
I'm sorry.
The word conditions as used in the second sentence must be deemed to relate to the conditions of the procedure. In other words, the rules of procedure.
My lord,
Does
yes,
not
I'm sorry,
refer
I'm
to the
confused.
conditions under which the enforcement of a convention award is to take place, in which sense the word is employed in the first sentence of Article 3.
Yes, my lord. No, my lord, I apologise. Yes, I agree.
And it maybe that's what the Italian, is it Constitutional Court, Supreme Court, Cassazione is saying. Unfortunately, I don't know what Article 825 of the Italian Code says, but it's quite difficult to understand without knowing it.
It is, as I understand the case, and we only got it a day or so ago.
Okay, well, we can look at it online.
Yes.
Probably.
But, my lord, what we do submit is that, in fact, requiring security for a challenge under 1035 harmonises the procedure in respect to convention awards with domestic procedure. As we've seen, Section 68(2)(g is subject to Section 77, which permits the court to order the payment of the award into court or by way of security for the application, and the application may be dismissed if the order is not complied with.
Isn't the object, of the second sentence of Article 3 this, if you stand back and look at it, we agreed that conditions in the first sentence refer to substantive conditions, that say they're the ones to be found in Articles 4 onwards.
Yes, my lord.
But Article first sentence then says you've got to recognise and enforce awards in accordance with those conditions under your own rules of procedure. And then the second sentence, which is concerned with the rules of procedure, is effectively saying, isn't it, and you mustn't use domestic rules of procedure which make it harder to enforce a convention award than it would be to enforce a domestic award.
Absolutely right. What it doesn't say is that you mustn't use domestic rules of procedure to make it harder to challenge a convention award.
No.
And indeed, again, in one of the late...
The question is, well, where in your domestic law do you get the power to make it, to enforce security as a precondition for being allowed to run a bona fide defence? You say, oh, well, that's within the spirit of CPR 3.
I do, my lord, and I was just making the point about harmonising both domestic and international procedure, because clearly the draftsman of the 1996 Act had thought it was appropriate to impose this condition on domestic procedure. And in fact, if you don't harmonise, you're giving greater protection to the domestic award creditor than you are to the New York award creditor against vexatious challenges to recognition and enforcement. So in fact, we would say that the spirit of Article 3 is actually invoked by this court recognising that there is a power that one can use the domestic procedure to achieve the same end of ordering security. Can I deal...
You're not, are you? Well, I think you are suggesting that you're imposing a more onerous condition on a New York Convention arbitration award, apparent arbitration award creditor, if you refuse to provide him or it with security in the amount in issue when you could do so with a domestic creditor. But is that a more onerous condition? It's not a You're giving greater protection to the domestic award creditor against vexatious claims. Well, wait a minute. Vexatious claims we're not talking about here.
Or any claim.
You're not entitled to be protected against a claim for which there's a defence.
You are well, it's the possibility, isn't it? It's the conferring of the jurisdiction upon the court. And what is being said here is a domestic award creditor has the protection of the jurisdiction of the court to award security in his favour against a challenger on public policy grounds. But the upshot of my learned friend's argument is that same protection is not afforded to a New York Convention award creditor. And if that is right, then we would say that that does make the domestic law more favourable and therefore discriminatory against the New York Convention award creditor. And so I do say that it would fall, particularly as interpreted on the basis of discrimination under Article 3. So harmonisation, we say, is appropriate. So, my lords, that is my submission on that point. I know the
Jurisdiction, because otherwise there is a less favourable position, which means
yes.
A more onerous condition, you say?
Yes.
Yes.
Now, my learned friends, in answer to my submission, make essentially 4 points in their written case, which I'll just summarise, then I'll answer if I may. They say, first of all, that if one construes the Act and Convention, there's no power to order security for a challenge under 1033. We say that's wrong for the grounds that we've said when looking at Article 3. They say, secondly, as a matter of policy, the Act should be interpreted to exclude such a power. We say the New York Convention does permit such a power. They rely upon the decision of the Court of Appeal in Dardania. We agree, respectfully, that there is no power under Section 1033 to order security. Indeed, or under 1035 as a condition of a challenge under 1033. But we'd like to address the court on what we say Dardania does decide. And then they say, in any event, there's no power under the CPR to make an order, and we say that there is such a power. So if I might deal with the first of those, the construction of the Act and the New York Convention, and they argue 3 points on the New York Convention. NMPC's case at paragraph 41.2, which for the notes is in the core bundle tab 6, MS page 79, they state that the structure of the relevant provisions of the New York Convention limit the power to require security to situations where the court is adjourning a decision on enforcement, i.e. Article 6, whereas there's no equivalent power in Article 5, reflected in sections 1035 and 1033. We say, again, summarising what I've said before, I think, that their point is misconceived because it does not recognise that Article 3 permits the application of local procedures. I don't need, I think, to go on further. It is self-evidently the case that 1033 makes no reference to security, but there is no need for it to do so. There's nothing in the New York Convention that limits a state's power to order security in accordance with its own procedural rules, and we rely upon the CPR. Their second point is there's no equivalent provision relating to challenge under 1033, similar to that under Section 77 of the Act. Section 1033, of course, reenacts Article 5.2b of the Convention, and the Convention has no provision equivalent to Section 77 because we say it was unnecessary for the Convention to do so because of the preservation of local procedural rules. Although, as we've already said, it was necessary to do so in relation to security under Article 6 for the reasons that Professor van den Berg said. And then we say that ordering an award debtor to provide security for its challenge is not expressly prohibited. Convention is silent, but it was also silent on ordering an award creditor to provide security for costs or freezing assets of the award debtor. And yet both of these procedures were held permissible in Diag and Dardania respectively. The latter, making a freezing order, is closely analogous to the civil law remedy of attachment, which Professor van den Berg says is a permissible local procedure. And then the third point, my learned friends say that Section 77 applies only to particular sections of the Act. Of course, this is literally true, but that does not establish that the powers under Part 3 of the CPR are tacitly excluded, while the powers to order security for costs or to make freezing orders were not. NMPC also refers to the decision of Mr. Justice Eder in Y against S, but I think, in fairness to my learned friend, he acknowledges that what Mr. Justice Eder said was unfortunately affected by the limited time he had available, and
What was
Indeed,
wrong? What was wrong with what Mr. Justice Eder says? I haven't quite gathered, although it's set out somewhere.
Well,
It's in your case, I think.
It's set out in our case, but I can take you to the paragraph. It will be if we go to
It's MS 103 in your case.
tab 16, 807.
Yeah.
There's a passage there at paragraph 33. And he said his tentative view was that CPR 62.18.9 speaks for itself. Successful parties prima facie entitled to an order nisi granting leave to enforce. But if an application set aside is issued, subject possibly to a counter strikeout, the award must not be enforced. Nothing in 62.18 which contemplates that such temporary prohibition against enforcement may be made subject to an order for the provision of security. Seems to me this is also consistent with, and then he cites a decision in this case, which with respect cannot be right, because he was dealing with a domestic award there, not a New York Convention award. Hence he was under CPR 62. There, where an enforcement order was held to be defective because the restriction on enforcement was not inserted into the order obtained, and two, section 7077 of the 1966 Act only applies to 67, 68, 69, does not apply to an application for leave to enforce under section 66, which is the domestic section. Consistent with 77, it seems to me that any application for an order requiring provision for security for the amount in dispute must be made in the context of a discrete application under section 67, 68, 69, supported by adequate evidence pursuant to statutory provisions. We say that all he was essentially saying was very much in that last sentence, that within the domestic regime, if you want to apply for security, you must apply in the context of where there are challenges under 67, 68 or 69. But that doesn't really advance the argument in this case at all. So
I know, I was just wondering what was wrong with anything you said. I mean,
well, no, I was saying it wasn't applicable.
I see. But as far as it goes, is it objectionable?
Well, it was slightly wrong in referring to IPCO, because, of course, IPCO is a convention case, and he's talking about Section 66. And
Seems to be referring to some previous iteration of this case, which we don't know anything about.
that was Mr. Justice Ross's decision.
Right, thank you. Right.
May I then move on to my learned friend's points on policy? We accept NNPC's point that the material provisions of the Act should be considered within the broader international context, and that conventions should be interpreted respecting their international purpose. But we say that does not address IPCO's point that the New York Convention permits each state to retain its own procedural rules as long as they don't discriminate against foreign award creditors. At paragraph 50 of my learned friend's case, they point out that the power to award security in Article 6 was directed to prevent abuse by the losing party starting annulment proceedings without a valid reason, purely to delay or frustrate the award. And that was a citation from the Travaux Preparatoires to the Convention, which I think my learned friend took you to this morning. We say the same risk of abuse clearly exists in relation to bogus challenges under Article 5 of the New York Convention, and that to argue from the absence of a power to order security that the draftsman intended to exclude the power under domestic procedure to make orders for security is, we say, illogical. If, as my learned friends say, that the power to order security in this jurisdiction is, quote, a domestic idiosyncrasy, that's their case at paragraph 52, it is, in our respectful submission, an idiosyncrasy expressly recognized by Article 3 of the Convention as part of its policy that allows states to impose their non-discriminatory conditions on the enforcement of awards and to make no provision at all relating to conditions applicable to challenges to awards. But even if it is legitimate to argue from the absence, the argument at very least cuts both ways in our submission. There is nothing in the New York Convention that expressly prevents a state from imposing procedural conditions on the ability to challenge a conventional award, for example, by the imposition of a time limit. And so the policy of the Convention is to facilitate enforcement of international awards and restrict challenges. We've cited in our case references to Mr. Bourne's magnum opus on international arbitration. There are some very lengthy passages there. I will, if I may, just give you the references to those. They are in the authorities bundle at pages MS 917 and passages at page 920 and 921, where he cites numerous decisions in different jurisdictions that say just that. The policy is to facilitate the enforcement of awards and restrict challenges. And indeed, he cites this case and the judgment of Mr. Justice Gross, as he then was. In our submission, therefore, it's strongly arguable that imposing security on a challenge by an award debtor serves that purpose. May I then... To facilitate enforcement and restrict challenges.
Discourage the taking of defences specifically provided for in the Convention.
No, my Lord, I wouldn't put it that way. Sure. We're talking about jurisdiction here. And it's the same question as clearly must have faced those who drafted the Act with regard to domestic challenges too. And of course, the policy of the 1996 Act is to make it, to put certain barriers in the way of challenging awards, as does the Convention itself, by limiting the particular heads under which it can be made, challenges can be made, and putting the burden of proof on the person who's challenging. So, I mean, that is very much the policy. And in the domestic sphere, it's been seen to be appropriate to permit the courts to order security against a challenger. We would say the same considerations must apply.
We just stand back for this for a moment. Where is the public policy interest in making it more difficult for a party which has got a bona fide defence from having it decided?
My Lord is arguing...
No, I'm asking a question.
Well,
why is it in the public interest that if somebody has got a bona fide defence, which is being remitted to a court to decide, it should be made more difficult for them by being required to put up with large sums of money?
That's why one has a discretion, my Lord, of course, because we're talking about jurisdiction here, and my Lord posits a specific point that where there is a bona fide defence, but of course the question of jurisdiction is a wider question.
Your answer to your Lordship's question might be, no, there isn't a public policy interest in that, but there may be a public policy interest in preventing a mana fide challenge. And that's the issue that one has to address if one's looking at jurisdiction rather than discretion.
Well, my Lord puts it better than I do.
That's the point you're making.
That is the point I'm trying to make, my Lord, yes.
But I suppose, then normally one deals with mala fide or flimsy defences by identifying a case where a summary disposal might be appropriate and saying, we're only going to allow you to defend on terms. That would be the usual way.
Yes, of course, and that's what no doubt motivated the draftsmen of the Act when they were looking at Section 77, to give that jurisdiction. What I say is that when you take that policy when you take the absence, if you like, on the prohibition of putting conditions on the right to challenge in the New York Convention, you take that all together, then there is no reason why there shouldn't be jurisdiction under the CPR, as expressly provided by Article 3, to be able to make that order in the appropriate case in this jurisdiction. It's a broad jurisdiction argument I'm making.
Yes, and we'll come to its exercise if it exists in a moment. Yeah.
Yes. May I then address my learned friend's points on Dardania? NMPC argues at paragraph 56 of its case that, which is for the note at page MS84, that Dardania stands for the proposition that a condition cannot be imposed which, if not satisfied, would lead to immediate enforcement and effectively deprive a defendant of his extant objection to enforcement under section 103(2) of the 96 Act. We say that the Court of Appeal in the present case was correct to distinguish that decision from the present case, in that it was Dardania, that in Dardania it was the award creditor who was seeking the adjournment of his own enforcement proceedings. I don't think I need take this court to the precise reference, but it is in the supplementary judgment, paragraphs 13 to 17, which is in the core bundle, tab 8C at MS page 171. In this case, it was NMPC, the award debtor, who applied for the adjournment, as was recognized to be the usual course of events by my Lord, Lord Mance, in Dardania at paragraph 27. And Dardania is behind tab 6. And as my learned friend pointed out, the relevant passages are really between paragraphs 27 and 29 in that judgment. And the price, again to use my Lord's phrase, the price of adjournment is an order for security, and in this case later replaced by an undertaking, and in the Court of Appeal it was increased. Notwithstanding that in 2008 NMPC applied in the alternative determination of the challenge under section 103(3), it was agreed by the consent order adjourning the proceedings and maintaining the security. So as at the date of the Court of Appeals order, the section 103(3) challenge was at least in abeyance. The NMPC was clearly content to preserve what was on the facts at that stage likely to be almost indefinite adjournment. NMPC recognizes that the facts of Dardania are unusual, but contends that one can derive the following principles.
But does it follow from your proposition that if somebody applied for adjournment and the adjournment was refused, the court could then impose on them a condition they bring in the amount of the award into court?
If the adjournment was refused and they were, forgive me answering a question with a question, and they are also making a claim under 103(2), or if they are just resisting adjournment.
They're resisting under a 103(2), yes.
I do say, my Lord, yes, that if they are also making a challenge under 103(2), there is jurisdiction to order.
Apply for an adjournment at all, would there be jurisdiction under the Arbitration Act then?
No, it's under CPR. It's always.
Why does the fact that they make an unsuccessful application for an adjournment make all the difference?
It doesn't, my Lord, unless I'm misunderstanding my Lord's point.
He must have done.
Well, I thought I'd put it reasonably clearly. I'll try again.
I'm sorry, my Lord.
As I understand it, you're seeking to distinguish Dardana or Dardania on the ground that in that case it happened to be that it was the judgment creditor who suddenly decided that enforcement was going to be a bit difficult and therefore there had better be an adjournment. But
the alternative view of Dardana is that what is critical is whether or not there's an adjournment. If there is an adjournment, then the price of the adjournment is, or maybe, security. On your case, I think it follows that if a judgment debtor applies for an adjournment as an alternative to raising a Section 103 objection to enforcement, and the adjournment is refused, then there is power in the court to order security, even though there wouldn't be power if there had been no application for the adjournment which was refused. That strikes one as a bit odd.
My Lord, there are two possible courses there. If the award debtor is seeking to adjourn but not raising a challenge, obviously there's an immediate enforcement. If he is seeking adjournment and then says, I will raise a challenge if there isn't an adjournment, he loses the application for adjournment, that goes away. He is then in the position of anybody who is making a challenge under 103.2. In my respectful submission, there is power in relation to anybody making a challenge under 103.2 for the court to order security.
I appreciate that, but sorry.
Whether or not there's been an application.
Whether or not there's been an application.
Whether or not there's been an application to adjourn.
Whether or not there's been an application to adjourn.
Your argument based on adjournment is irrelevant to this point, then. Because the power you submit exists anyway.
I do submit it.
We've now got back to the common law. What I was focusing on was Dardana and its analysis of the Arbitration Act. And I do accept that, at least in terms of the Arbitration Act sections 103 and 4, or section 103 really, there is no power there to order security except upon the grant of an adjournment.
Absolutely, my Lord, yes.
At the instance of the applicant, of the judgment debtor.
Yes.
If it's at the instance of the judgment creditor, of course there can't be a power. That's also
No.
decided in Dardana.
And I think my Lord also recognised, or was prepared to recognise, that the court could do it of its own volition too.
Yes, I mean, I see the doubt thrown over about that, and so I wouldn't wish to stand on that or try and explain what I had in mind. I think it's Solly, the previous case, Solly, whatever it is.
Solly Bonnet, yes.
Yes. Anyway, all right, so we got back to the point, have we, that really Dardana says nothing on the present issue in relation to domestic rules, because it wasn't argued in Dardana.
Indeed so.
I mean, the question I'm interested in is to what extent you are saying that under the Arbitration Act, section 103, the position is that security is catered for in all situations, or whether you rely exclusively on the domestic rules, which you say get in through Article 3 and a different section of the Arbitration Act, namely section, I think, 102.
I rely upon the domestic rules in this case. I do not, for one moment, demur from what my Lord said in Dardana, that there isn't a power under 103.5 to order security except in connection with an adjournment, and that 103.5 provides no basis for ordering security for a challenge under 103.2. But beyond that, I say that my learned friends try and derive principles which go beyond those findings and interpret my Lord's judgment further. My Lord accepted that a freezing order could be made, and this is consistent, of course, with the preservation of local procedural rules under Article 3. We would submit it would be strange if the state court were permitted to impose conditions, yet prohibited from imposing sanctions for their breach, which, of course, is what Justice Burton was talking about in the Diag case. So if, for example...
I don't think it's suggested by your opponent that there isn't an ability to impose sanctions upon a breach. We discussed expressly discovery, for example.
Yes.
I mean, obviously, if somebody behaved in a breach of the rules in the course of conducting a Section 103 issue, the usual sanctions could be applied. I think that's accepted.
Yes. So, but my Lord, we do keep on coming back to a point that I think my Lord Sumption focused on quite early in the argument, which is whether or not then essentially the ground is occupied by Article 6, so as to preclude the any power that might exist under local procedural rules.
Yes, your answer to that is you needed Article 6 because some procedural systems, some civil systems didn't have it.
Yes, my Lord, that is...
So you cannot infer that it was shutting it.
That is my... And I know I've said that a couple of times.
Are we confident that all procedural systems have CPR 3.13?
We are not confident.
Yeah, I mean, I would have thought the same point could apply. It must be extremely doubtful whether other systems have all the procedural powers that we have.
And that is why Article 3 allows that diversity.
I'm not sure it doesn't go the other way. If you're drafting an international convention that is potentially designed to apply to 150, 200 states, you basically have no choice but to ignore the idiosyncrasies of particular procedural regimes and say, well, we will set out our own self-contained scheme, at least in the essential respects. Here it is, and the procedure locally can only operate round the edges of that, which, to my mind, rather reinforces the complete code argument so far as it relates to matters that are covered, in some sense, by the Convention, obviously not matters like discovery and so on, which are not.
Well, my Lord, there is, for example, a huge disparity, as we know, between jurisdictions in terms of time limits for raising a challenge from, I think one of the writers said, 3 months, 30 years. And a time limit is a very serious, clearly a very serious fetter on the ability to bring a challenge if it becomes statute barred after 3 months. So the draftsmen of the convention were willing to permit that diversity, if you like, of...
Wait a minute, it's inconceivable that you could have a time limit in England for the bringing of a challenge to a Nigerian award which didn't run from the date when enforcement was sought in England. I mean,
yes,
domestic law might be mad, but I doubt if it's that mad anywhere.
Well, yes, but we could have provided, but we have no time limit in this country.
No,
but,
so I mean, in that
but
sense,
other countries do.
The draftsman of the convention would have assumed that time limits would run in a reasonably sensible way from the date when it became material to raise a challenge.
Yes, but we know...
Enforcement was sought.
I'm sorry, my Lord, I spoke over you.
I'm sorry.
But we know, again from the commentators, that and from what Professor Vandenberg said, that the draftsman of the New York Convention would have liked to have had a uniform procedure, but couldn't, particularly given one of these issues of time limits. It would be possible to have a time limit in a jurisdiction to say that you only have 28 days to challenge an award, but we don't have that in this country. Apparently, it is in other countries, and that's a very serious.
Yes, I mean. I can't think that they contemplated that the time for raising a challenge in respect of a Nigerian award in this country should bear any relationship to the time set for raising a challenge to a domestic award, because it's a completely different exercise, enforcing a foreign award and relying on a domestic award.
Well, we are at the far extreme of the international community in having no time limit upon challenging an award, but other jurisdictions do, apparently. And the point I was just trying to make is that if the draftsmen were willing to contemplate allowing that diversity of time limits, for example, which clearly are a fetter upon the right of challenge, that would be a much greater fetter than, for example, the provision of security, because it doesn't make unless of course there's a breach of it, it doesn't make the challenge inadmissible in any way. So, but my Lord, just finishing, if I may, on Dardania, we accept, as I say, that the case is clear authority, and we respectfully agree with the ratio that there's no power under Section 103(5) to order security, except in connection with adjournment. But we say that my learned friends go further, and in fact, when one looks at paragraph 29 of the judgment at page 609 in the bundle, MS 609, my Lord was there making a very fact-specific finding where it was the award creditor itself who was making the application for the adjournment, and yet asking the award debtor to pay for an adjournment that he did not want. And we would respectfully agree that the imposition of security in those circumstances was self-evidently illegitimate. But we say that my learned friends are wrong to derive any principle of general application from paragraph 29 of my Lord's judgment in that case. And we do not accept that in an appropriate case, if security is ordered under Section 103(5), properly ordered, it cannot also be accompanied by an order that where a challenge is threatened in this jurisdiction, which will be heard before the challenge at the seat, that there can be an order that the challenge in this jurisdiction is subject to conditions, for example, the provision of security.
Are you going to examine the circumstances in which that might be the case domestically? I mean, there are 2 points. Firstly, does CPR 3.13a contemplate attaching conditions to a right to defend yourself or right to advance an answer of this type? And secondly, if it does, when would such conditions be attached properly as a matter of the proper exercise of discretion? Because we have to recognise that the Court of Appeal, on one view, hasn't exercised a discretion under 3.13a. If it has exercised a discretion, I think the basis of the discretion is challenged.
Well, my Lord, I was going to move on to CPR 3.13a and my learned friends' attacks upon it. Their first, which is at their case at paragraph 65(1), page MS 87, say that it would be wrong to use a procedural power where the power is to require security is subject to the express legislative regulation in the 1996 Act and the New York Convention. And our simple answer to that is the submission that we've made in Article 3 already. My learned friend then goes on in paragraph 62 of their case to refer to the Huscroft and P&O Ferries limited decision. My learned friend has already read the judgment to the court in that case, and so I'm not going to go back to it, but just in case my lords would like in their note where it is at this stage in the argument, it is in Authorities, tab 12 at pages 750 to 751, with the passages my learned friend read. We respectfully submit that the provision of security for a challenge is in fact the antithesis of a freestanding order divorced from some other form of relief, which is what Lord Justice Morbick was talking about. We do say that the imposition of the condition in this case was directed at exercising control over the future conduct of the litigation. It was directed towards the resolution of IPCO's application for enforcement of the award, as the court said, within a reasonable timescale and with a...
How does it help that?
Sorry, my
How does
lord?
it help the timescale, which is under case management? What possible good effect could it have, except possibly to lead to some delay due to the appeal to this court?
It hasn't done happily, my lord.
No, I mean, but in reality, it's nothing to do with that, is it? The security is to help the judgment, the award creditor, if they succeed. Ultimately, it helps them a lot, but it doesn't help the process of deciding whether they should succeed.
Well, my lord, the Court of Appeal clearly formed an opinion from the history of the proceedings without making any findings one way or the other as to who was to blame, that there had been delay, and in its discretion clearly felt that there was a salutary purpose for the...
We've been around this ground before.
Yes,
I mean, if that's the position where we get back to, let's move on.
Okay, my lord, yes. And indeed, I mean, just on the Huscroft case...
I mean, is there any other basis on which this security could be explained as serving a useful purpose, apart from being very useful for the judgment creditor?
Well, my lord, I'm not going to repeat the point that I made, that the Court of Appeal looked at the entire history, and that's the view that they took, and that it was a legitimate exercise of its discretion in my submission. And indeed, as Lord Justice Moore-Bick recognised in Huscroft, that he used the expression that all cases are infinitely variable, and indeed the circumstances of this case, we say, are plainly out of the ordinary.
Is there anything in Huscroft which you want to refer to as supporting the grant of the order for security on this case? Huscroft talks about security being ordered as a condition for relief, as a proper price for relief, and so on, and it also uses the word you mentioned a moment ago, exercising a degree of control over the future conduct of litigation.
Yes.
Or punishing a party who, without reason, failed to comply with established procedural code. But what about the first point, proper price, condition of obtaining relief? How does that fit in? Does it fit in?
My lord, I would say, I'm sorry to keep on repeating it, but it is against the background.
It's the price of defending yourself, or price of advancing your case.
It's the price of challenging. Well, I started at the very beginning by saying that one shouldn't regard NMPC as a defendant, but as a claimant or a challenger or appellant, and so it's very much in the same position as somebody.
It's odd, isn't it? Because it doesn't look as if a relevant consideration is the risk of not being paid, nor is it security for costs, which is what these things are usually about. I mean, security is usually, I want to be secure, I want my claim to be secured, because the other side will spirit it away. I'll never see that if I get a judgment, it'll be no use to me, or if I get an order of a cost, it'll be no use to me. That doesn't seem to be part of this argument at all.
Anyway, it would be better resolved by a freezing order.
Well, quite.
Well, my lord, the argument...
No freezing order was sought. And so we can only proceed on the footing that it's assumed on all sides that whoever loses will be good for the money.
Well,
whether that's true or not, I don't know.
well, my lord...
How easy it'll be to get the money might be another question.
Well, yeah, well, there is that, my lord, and all those submissions were ventilated both in the first instance court and in the Court of Appeal, and dealt with...
But in relation to NNPC, I thought they were related in relation. They were ventilated in relation to your client.
Well, there was a great deal of argument about NNPC's delaying tactics.
But there was no argument, was there, to the effect, certainly doesn't seem to be reflected in the judgments,
No.
to the effect that if, at the end of the day, their challenge failed, they would pay on the award.
No, my lord.
Whereas there was an argument to the effect that if you got the money and they subsequently got it set aside, they wouldn't get it back.
There was that, fine. And we have the, I mean, the judgment speaks for itself on those points, my lord, yes. Sorry, my lord. Yes, my learned junior reminds me that the Court of Appeal did say that there was no guarantee that NMPC might exist in its current form in due course.
Well, it seems most unlikely that if it didn't, arrangements would not be made for it to meet its outstanding liabilities,
Well,
unless it's insolvent, which hasn't been alleged.
no, my lord, that's not been alleged, but that's something I can't take further without evidence.
I think that was in that comment, was it not? It's in the context of the Nigerian litigation continuing for several decades, rather than what was going to happen if a trial was held next year in
Yes,
in
well,
London.
and indeed the evidence was that it could be 40 years before the resolution of the proceedings in Nigeria.
What about the other aspect that I asked? If one is talking about a jurisdiction, a Huscroft type of jurisdiction, there's a case which we were referred to, which suggested, I think, that the test should be something like flimsiness. Is that right? Under Section 70.
I think my learned friend referred to the Conoco.
Was that? What do you say about that?
This is sort of argument goes on in Order 14 type case.
Yes. Yes.
YNS is it? 800.
But this has been held not to be a sort of iffy Order 14 case, rightly or wrongly.
No, there was no finding that.
So all the jurisprudence about how I ought to have leave to defend, and on the other side ought only to have leave to defend if they put up the money because it's a pretty iffy sort of case. None of that's live here on the facts.
But it is important to understand the structure of both the award and the challenge. And again, it does come out from the judgments that the challenge is two-part of the award, and indeed the argument before both the judge below and the Court of Appeal was that one can ring-fence the part where there is a prima facie case of fraud.
That argument has failed because the courts below proceeded on the basis that under Nigerian law, if this award is substantially or partly induced by fraud, then the whole award fails. And we haven't got any means of going behind that or trying to divide the award up into bits.
No, my lord, they didn't find that was what the position was under Nigerian law. They found that was an arguable position.
Yes.
Under.
Well, that's what we're proceeding on.
Yes.
For the base at the moment.
But once you say it's an arguable position, you can see that it may also be wrong, and consequently there may be a balance to be struck between that argument that all of the award goes and only part of the award goes, and so because as to the rest of it, the Court of Appeal had already decided they weren't interested any longer in adjourning the enforcement for the non-fraud challenges. And so it was only the fraud challenges from the Court of Appeal's point of view that were alive. I mean, that was subsequently superseded by the agreement of the parties to bring the non-fraud challenges from Nigeria to England. But from the Court of Appeal's point of view, when exercising its discretion, it basically was finding that all of the award should be enforced by reason of delay, but there is this argument as to fraud. It goes to part, it could go as to the whole of the award. And so there is a balancing in my submission.
Well, either it's arguable or it's not. I mean, if there's if it is properly arguable that there is a defence to the whole, isn't that what we're concerned with? We can't say that it's relevant that part of the reason for there being a defence to the whole is that there is fraud in part.
Well, what the Court of Appeal found is that there was the way they put it was that there was an argument at least as to part, is the expression used in the judgment. And if we're trying to understand what the Court of Appeal's exercise of its discretion was, that's what informed its thinking.
When you say their starting point was to say that the whole of security ought to be ordered because of the delay, what more particularly do you have in mind by the delay? The period the court was looking at, wasn't it, was the period it would take following the order for remission to the commercial court, for the commercial court to deal with it. Is it apposite to describe that as delay?
Well, my Lord, I think the Court of Appeal, if one reads this judgment, and I'm sorry to go over all the ground, was that it looked at the whole history.
But what's the relevance of that? If they're saying, right, now the next step is to get on with this, we're not ordering enforcement because there's a bona fide defence. Nothing much is happening on Nigeria or looks like to be happening, so this could go now to the commercial court for positive determination. It was then looking presumably at a period of maybe some months, depending on the state of the commercial court list, which would be out with the control of the other side, or indeed yourself. So, in that context, what's the relevance of all that's happened in the past to deciding whether there should be security for the full sum or any sum put up in order to allow them to proceed to this determination as soon as the commercial court can hear it?
My Lord, up to that stage, we'd had 8 years.
Yeah, but so what?
It's not a penalty.
No.
Well, you've got 100 million already. I know they're trying to get it back by some stuff like
Yeah, I think we must remember to ask about that footnote. But the case I had in mind about flimsiness is A against B.
Yes.
I mean, is that you say that's the wrong test domestically? It's
where is it?
It's tab 3 in bundle 1.
Thank you, my Lord. My Lord, I say there are, it's a discretion, and clearly there are numerous circumstances in which it could be exercised, and no doubt a flimsy defence is one of them. As my Lord Clerk said, it's very much a summary judgment.
That's the front,
Test.
yes. Yeah. Right, now I'm conscious that time is moving.
Yes, I have, I think, probably...
You've got a little more beyond 1:45 because your opponent overran.
Well, my Lord, I thought I had 2 hours this afternoon in any event, but I shan't...
Oh, yeah, you have 2.25 hours.
So I had 2.25.
Yeah, I think you have... I think not quite 2 hours. Not quite 2 hours this afternoon, but yes, about yes. You started at 12:38. So 2 hours less 7 minutes.
Well, my Lord, I'm grateful. I will finish. I will deal then. I'll deal with my learned friend's wrong in principle arguments, if I may. His first argument is a defendant cannot be required to provide security for the amount claimed under threat. If it didn't do it, would be debarred from advancing a good prima facie case. The second point is a requirement to provide security reflecting a substantial part of the value of the claim as a price simply for having access to the court for the person advancing a substantive defence to a claim would violate Article 6. His third point is wrong in principle for an enforcing as opposed to curial court to require security of the price of resisting enforcement on a grounds the defendant is required to increase the assets amenable to enforcement. And his fourth point is it would be wrong in principle to require security as the price of resisting enforcement when the defendant is arguing on the basis of a good prima facie case. As to his first point then, I need only, I think, repeat briefly, we say NNPC is not a defendant. It is a challenger or an applicant. On the second point, we say that fails for the same reason. Where somebody is making a challenge, that cannot fall foul of the ECHR, and indeed, if that were correct, then Section 77, as a matter of principle, would also be contrary to Article 6, and that can't be right. As to the third point about bringing assets within the jurisdiction, that point was roundly, and we say correctly, rejected by the Court of Appeal in the supplementary judgment at paragraph 7, which is to be found in Core Bundle tab 8C, MS page 169. And indeed, NNPC has never adduced any evidence that it has insufficient assets within the jurisdiction, but instead has always insisted that it was good for the money, again noted by the Court of Appeal in the supplementary judgment at paragraph 12, Core Bundle, page MS 170. NNPC submits to this court that to allow security would encourage creditors to seek enforcement in England, even if there were no assets and no limited assets here, while conceding in another of its footnotes the well-known case of Rosseel, which of course states that presence of assets from the jurisdiction are not a condition of enforcement under the New York Convention. And indeed, my Lord, Lord Clark, in the case of TMSF against Demirel, which for the note is at tab 15 in the bundle of authorities, at page MS 789, recognized that not only can one seek enforcement of a foreign judgment where there are no assets, but there may nevertheless be juridical advantages in doing so, such as aids to enforcement that one can obtain by obtaining an English judgment. And so we say, as a matter of principle, there is nothing wrong, even if there were no assets, in encouraging creditors to seek enforcement in England. And then finally, the fourth and final point really does go to discretion. And we say that the Court of Appeal had well in mind, on the evidence that so far emerged, that there was nevertheless a prima facie case that the award had in part been obtained by fraud, and that was the main judgment, paragraph 136, core tab 8b at page MS 154, but nevertheless it exercised its discretion, we say, on a fully reasoned and appropriate basis. And we'd like to draw the court's attention to the following paragraphs of the two judgments in this case, where we say the discretion was exercised properly. Main judgment, paragraphs 179 to 185, which are in the core bundle at MS pages 162 to 4, and the supplementary judgment, paragraphs 18 to 26, core bundle, pages MS 171 to 173. And so hitherto, we had security as the quid pro quo for an adjournment under Section 103.5 that NNPC had purchased for 12 years. And now, just as a security may be called upon, it claims it was never necessary, or at least not necessary for the last 8 years, since it first raised the spectre of the 103.3 challenge. We say that if NNPC is correct, the security always was illusory during that time, and the court's orders were in vain. At any moment...
It may not be correct on this. I mean, it's one thing to say that there's no power to order further security when you're refusing an adjournment and directing trial of the issue. It's quite another thing to say that there was no power to order security when it was ordered for 80 million, or that those orders have, in some respect, become nugatory, having obtained years of adjournment through them.
Well, my Lord...
I mean, that's the footnote point.
Yes, well, my Lord, I won't labour that point.
Well, I will have to hear what is said, but Mr. Landau suggests in the footnote that that point might be left floating in the air, but I'm not sure it's very satisfactory to do so, and we may want to hear him on it briefly.
Yes.
I mean, you say it can't be true. They've had adjournment for years and years, and there was perfectly power. And at the very lowest, it's a matter of discretion whether we release the security now.
Absolutely, my lord.
Yes.
And it would be a license.
Yeah, it was a consent order. So
It was a consent order.
So that we wouldn't have much discretion, although we might have some.
No, my lord. It would be a license to award debtors to avoid the security provisions by simply raising.
Enough is enough. You've got quite a lot of security, and what are you complaining about?
But my lord, I think there's nothing else. My lord, I think I've come to the end of my submissions, unless there are any other particular points that the court would like me to address.
Or any other points? Any other points? No. Well, thank you very much, and we must commend you on that. Mr. Knight, is there anything you want to add? Thank you much.
Mr. Landau. Do you want to just address anything you want to say on the footnote point?
Yes.
Because I think you heard the initial reaction at any rate.
Lords, the footnote follows the logic of what we say is the finding that this court should make on the main point, which is that insofar as there is a power under 1035 to order an adjournment, then security is part and parcel of that. But as I have sought to demonstrate in the course of my submissions, the 1035 point now has gone completely. There isn't a 1035.
Well, not for the future, but there has been adjournments in the past.
But there isn't any. Now there isn't any adjournment.
No, but I mean, you can't rewrite.
We've had the benefit of that adjournment for years.
Yeah, you can't rewrite history.
Moreover, there's a strong public interest in not allowing parties who've entered into an agreement then to unscramble it, because afterwards they say we shouldn't have entered into that one.
Well, on that point, my lord, there was an agreement by way of the consent order. It was consent order,
yes.
which it has been my learned friend's case should now be unravelled.
I know, but if you defeat that, you're actually seeking to unravel it in a different respect.
Well, the logic of the point is really on the basis of Dardania,
Yeah.
which is whether or not security is appropriate as a condition for defending under Section 103, in that case 2, and for us 103.3.
But that security was originally ordered not as a condition of being allowed to defend, but as a condition of obtaining an adjournment which you got, and which resulted in the English proceedings running about 7 years later than they otherwise would. The other problem is that I think the law is normally that if you have a consent order, you can only get out of it on grounds analogous to those which would enable you to rescind an ordinary contract.
But except that the basis upon which we're proceeding at the moment is the Court of Appeal's finding that the consent order is now subject to a change of circumstances. So that consent order is no longer operative.
Well, that means you can. Well, not. I'm just looking at the Court of Appeal. What do they do to it? They didn't set it aside completely. They said that the previous security should stand. They presumably set aside. They must have set aside the adjournment. They set aside the adjournment. So what they did is vary it in part.
Well, they didn't exactly set aside the adjournment. They simply said the adjournment has now got to come to an end.
What's your answer to Lord Sumption's point? We've got chalk and cheese here, because the present additional security is to fetter the ability to have a matter heard now by the commercial court as soon as it can hear it. That's a completely different type of animal from what happened in the past, which was that you sought a postponement, you achieved postponement for a very substantial number of years, so you have had a benefit. What's the answer to that point?
The answer is that the benefit that we've had was not the benefit for which that security was actually put up, because the security was put up pending a decision in Nigeria.
And there was,
And there's been no decision.
still
in
have
Nigeria.
was waited for a decision
Yes.
in Nigeria until the Court of Appeal said enough is enough.
Yes.
The wait has now stopped.
And enough is enough, which meant undoing the consent order,
No.
and also moving away from the basis upon which that security was originally
It meant
ordered,
saying
which
that
is
the consent order wasn't going to regulate matters for the future.
well. I can.
I mean, you by the consent order gave certain undertakings, and they are at our disposal, I think.
Yes.
We can either release you or we can require you, as the Court of Appeal did, to stand by them.
Yes.
Yes, right.
You've got limited time for your reply. Do you want to take up more of it on this point?
There are questions and there are questions,
Any
and
words,
so
please?
therefore on that one.
What about your reply then?
Then in terms of my reply, there are not many points. There are just a few points I want to pick up on, if I may. The nub, or perhaps the most significant point that is being emphasised by my learned friend, is the territory that is actually occupied by the New York Convention. What does Article 6 cover? What does Article 3 allow to be covered by local rules? In the course of that submission, my learned friend in my submission is taking an unrealistic, overly granular approach.
Overly what?
Granular.
Granular.
Yes. I know it's late in the day, but it just occurred to me.
Is that a culinary?
It's actually...
Well, they're rather good for you, granular foods, but... right.
I'm not going to take up more time in my reply on granular, but...
Overly
but
granular.
yes, because
Grinding too small. Right.
Yes. Because he's splitting up, the core distinction that he makes is challenges to enforcement on the one hand, and he talks about fettering enforcement as against fettering challenges. That's the distinction he's drawing. So he says that Article 6 is talking about challenges to awards, and in particular, challenges at the seat. Whereas the distinction is challenging enforcement. But all of that is part of one unified scheme of the New York Convention. You only get to Article 6 of the New York Convention through the window of Article 5. Article 6 qualifies a defence under Article 5 to enforcement. It's all intimately joined up. So Article 6 is conditioning the ability of a party to resist recognition and enforcement under Article 5. You go to the court under Article 5. This would be, of the New York Convention, it would be 5(1)(e). You are arguing that the award should not be recognised and enforced because it has not yet become binding on the parties or has been set aside or suspended by a competent authority. So that is your defence, and that is what is regulated then by Article 6. Article 6 says, well, that could be deferred depending on what's happening in the local courts, but in the course of that there may be an order of security. It's all part of one scheme. You can't take out one part of that and say, well, no, that's about challenges at the curial seat, and this bit is about the enforcing court. It's all connected. Yeah. In the same way as if indeed there is some generalized discretion which comes into the New York Convention by virtue of CPR 3.13a, then how does that sit with, for example, the may discretion in Article 5 of the New York Convention?
Now, with reference to the general power under CPR 3, I see there are various copies of the White Book on the table. Would it be possible, please, to give us a short list of the specific provisions for security of costs which you get elsewhere in the CPR?
A list of the provisions in the CPR that address security for costs?
In one way or another.
Or security for the claim?
I think security for claim, principally.
Right.
But because I just would like to see how they sit alongside
yes.
the asserted general power.
Yes. So I will say yes on behalf of the team.
Can I just get your last
yes.
rhetorical question? How does a CPR 3.1
yes.
3 discretion fit alongside?
There's a discretion, as elaborated elsewhere in Dardania and UKOS,
Yes.
discretion in Article 5 of the New York Convention with the use of the word may.
Oh, yes, yes.
So a court, because of the word may in the New York Convention, might not apply a defence in Article 5 of the New York Convention to defeat an award. But we know from Dardania and UKOS that may is subject to narrow construction. It's only a recognisable legal doctrine such as estoppel or agreement.
Well, or possibly, yes, I mean, I think...
It's got to be determined as a claim of right.
Yes.
And not
yes.
procedural discretion.
And yet, on the Learned Friends case, over and above that, through Article 3, you would have some generalised procedural discretion coming in. Through Article 3, 3.1 of the CPR, you've got the court can somehow restrict access to those same fundamental protections in Article 5 by reference to some broad discretion.
Yeah. I mean, I think May does go a bit wider, doesn't it? It's been held to go to the point where if the award has been set aside by a court of appeal, which
yes.
Has reached an obviously suspect.
Yes, and that was UKOS, another Rosneft.
Yes, Rosneft.
In fact, and there's one other as well, which is de minimis. De minimis has also been recognised as another something that comes under technical.
Right. Anyway, we've got that. So you say 2 sort of conflicting schemes of discretion.
So and this goes. I'm trying to avoid the word granular now, but this is all a scheme in Article 4, 5, and 6 of the New York Convention. You can't just take out one little element of it, which is what Malone and Friends' argument depends upon, and once you see it as a scheme, then we come back to the way it was described by Lord Justice Ricks in the Gator Assets case, which is on the footnote on page 12 of my written case, where he said, this is a complete code on every aspect of security. And that is to be preferred in my submission to the first instance judgment of Mr. Justice Burnett.
That was footnote what? Footnote 50?
It's page 12 of my written case, and it is footnote 11, and it is paragraph 82 of Gator Assets.
Right.
Next, there was much made of who is the proper claimant. Where this may matter is on the last element of the argument, which is discretion. What I wanted to hand up to the court, if it is of assistance, is a short passage from Mustel and Boyd, which makes good the point that I asserted in the course of my submission, that the introduction of a summary procedure for recognition and enforcement did not have any substantive impact. It was simply a procedural improvement on the old common law action. But it still has in it implicit the substance, which is you have a claimant who is the award creditor. And it is unlike in the case of a judgment, which is self-executing, if you are an award creditor, you have got to go through the stage of having a court recognize that you are indeed an award creditor and recognize and enforce. And you do that by way of claim. In the old days, it would be by a full action. In the new system, it is by way of a summary statutory procedure. And in response, the respondent is indeed a respondent, defending against that. And so in my respectful submission, Lord Justice Ricks was incorrect in his analysis. Lord Justice Buxton is to be preferred. I haven't given you the citation to I don't think, Lord Justice Buxton in the Gator case, but the same point is made, which is why he makes the distinction on the basis that awards are different to judgments. This then takes me to a related point, which is the relationship between Section 67, 68, and 69 of the Act and the provisions on New York Convention. A lot of Lord Justice Ricks's analysis is based upon the effect of Sections 67, 68, and 69 and the presumptions that are there. This links, in a way, to Malone and Friends' argument about harmonization, that we should read all of this across to the New York Convention and deal with it in the same way, 77 and the New York Convention. This overlooks the fundamental distinction between active and passive remedies. Section 68 and Section 67, 69, they're not the equivalent of Section 66 enforcement or the New York Convention recognition and enforcement. They're totally different animals. 67, 68, and 69 are active remedies where you take an active step before the courts of the seat to set aside an award. You do that erga omnes. Once the award is set aside, unless you are in France and some other limited jurisdictions, that award can't be recognized and enforced anywhere else. The award is then killed at the seat. That's not the same with recognition and enforcement. A denial of recognition and enforcement in one jurisdiction doesn't automatically lead to a denial of recognition and enforcement in another jurisdiction. The difference is explained by the difference between an active and a passive remedy. On the one hand, you are taking an active step to set aside the award. On the other hand, you're simply defending if somebody comes to enforce against you. And that explains why Section 66 is different.
How much is within Section 66? I think Mr. Black referred us to an authority which he indicated suggested that you usually had to take a fraud point under Section 68, for example. Or was it Section 67?
Well,
Under Section 68, yeah. He pointed to Section 68 2G, a reference to fraud there, for example, and he said...
Sorry, Lord, I'm not sure I understood the point.
Mr. Black, what was the case you referred to on that point?
It was Lord Justice Ricks in Gator, wasn't it?
It was Ricks and Gator again, yes.
Yeah.
But the point...
that if I think the effect of the argument was that if you could bring yourself within either, you should go under Section 68 and you shouldn't just rely on Section 66. Is that...
I think it's paragraph 79.
Yes, that is...
Well, I'm not sure
I'm not quite sure
the reasoning behind it.
And I'm not sure where the
I think he
point
was simply
goes.
saying it's rather odd if, by not going under Section 68 and simply defending, you make yourself less vulnerable to a security order than you might otherwise have been.
So which paragraph again?
I think it's 79.
Yes, but there would be a logic to that because of the different juridical nature of what's going on in each case. On the one hand, you are taking an affirmative stance and bringing an action to set aside an award for all purposes. On the other hand, you are taking a passive step and simply defending against the other person's action for recognition and enforcement. So this just comes back to the difference between active and passive remedies.
Yes, it is. It's paragraph 79. It's MS 724. It's left-hand column towards the bottom.
So, my Lord, my point is...
I see he does postulate that you could do either, but he
Yes.
just says you shouldn't be in a better position.
But I think my point is that overlooks...
That's because of his view that you
Yes.
will be a claimant
Yes.
whichever way round you're
Yes.
taking it.
Yes.
Yes, I see. Yeah. Right, well, we better...
And just the last... I think it's 4 o'clock, but just one other point on this. My friend's got what is maybe a slightly complicated argument under Article 3 of the New York Convention about harmonization, non-discrimination, which I think he's looking at the second sentence of Article 3. Article 3 does two things. It doesn't do one thing. Article 3, in the first line, talks about an obligation to recognize and enforce through local rules of procedure. The second sentence deals with non-discrimination, two different things. In the first sentence, in terms of the obligation to recognize and enforce, that is subject to the conditions of the Convention, Article 4, 5, and 6. The point my learned friend's making on harmonization confuses active and passive remedies. Article 3 and the New York Convention says nothing about remedies at the seat. It's not about active remedies. It's about recognition and enforcement, not setting aside. So this point about harmonization is flawed. Article 3 is not concerned with that. It's only concerned with the passive, an international regime for passive remedies, recognition and enforcement, and defenses. It is, of course, the model law that took the next step to harmonize setting aside at the seat, but the New York Convention doesn't deal with that. Anything else? the last point, after my previous last point, is this Dardania. Dardania has in it what I've described previously as points of principle, which are critical in this case.
The Dardania wasn't concerned, or it wasn't argued on the basis of the CPR.
No, it wasn't.
It's, you say it's authority for whatever it decides on the new convention. And,
yes.
Well, tacitly, the council can't have thought CPR was relevant, but
that's
what we have to decide.
And it doesn't get swept away by 3.1 of the CPR, because there are critical points of principle in Dardania, and that point of principle in particular about not fettering by security access to a defence under 103.
Yes.
So that, if that's a key point, which in my respectful submission must be correct as a new convention point, it can't be swept away by CPR 3.1, whether one sees that as jurisdiction or discretion. And there is simply no answer in my submission presented by my learned friend, or indeed the Court of Appeal, to the point I had made, that the difference between whether it's the award creditor or the award debtor who's making the application, it doesn't bear upon that principle at all. It doesn't make any difference. That principle stands. Lords, unless I can be of any further assistance, those are my submissions.
Thank you very much. The court's grateful to counsel and will reserve its judgment, which will be given in the usual course. Thank you very much. Court is adjourned.